How the DOJ's own answers are raising more questions than they resolve. Something is wrong with this story. Not wrong in the way political scandals usually go wrong, with accusations flying and sides taking shots at each other. Wrong in a deeper, quieter, more unsettling way. Because when the official in charge of transparency stands before the cameras and says everything is fine, and the evidence directly behind him says otherwise, that is not a political dispute. That is a contradiction. And this particular contradiction sits at the center of one of the most significant legal cover-up questions in recent American history. Tonight, we are going to walk through it, step by step, evidence by evidence, because what is happening right now inside the United States Department of Justice, inside Congress, and inside the Epstein files investigation deserves a clear, honest, forensic examination. So let's begin. Let's establish what we know. Jeffrey Epstein died in federal custody on August 10, 2019. The official ruling was suicide. He was awaiting trial on federal sex trafficking charges that implicated a network of powerful individuals, politicians, financiers, and international figures across multiple countries and multiple decades. His death raised immediate questions. Questions about security failures. Questions about whether the guards on duty that night were doing their jobs. Questions about who may have had a motive to ensure Epstein never made it to trial. Those questions never went away. And now, years later, Congress passed a law, a veto-proof law, demanding that the files be released. Demanding that the American public be given access to the evidence collected around Epstein, his network, his crimes, and the investigation into his death. That sounds straightforward. Release the files. Let the public see what the government found. But here is where the story changes. Because releasing the files turned out to be more complicated than it sounded, a lot more complicated. Let's talk about Pam Bondi. Bondi is the current Attorney General of the United States appointed by President Donald Trump. Before this role, she served as Florida's Attorney General, a job that placed her in proximity to Epstein-related legal questions during a period when Epstein received one of the most criticized prosecutorial deals in American legal history. When the Epstein files became a political priority, Bondi stepped into the spotlight. She made a claim, a bold one. She said she had a client list on her desk. She said there were files, real material, evidence that the public would finally be able to see. Trump supporters celebrated. The promise of accountability, the promise that powerful names would finally be exposed, generated enormous excitement. But then something happened. The binders arrived. The documents were released, and what people found inside was not what they had been promised. Pages were missing. Key sections were redacted. Names that people had been told would be revealed were not there. What had been framed as a dramatic disclosure looked, to many, like a carefully managed information release designed more to satisfy political pressure than to actually deliver transparency. This became known as the Binder incident. Some called it Bindergate, and that word, incident, does not quite capture what it really was. It was a betrayal, a serious one. Bondi's own base turned on her. The people who had been most energized by the promise of Epstein accountability, many of them Trump supporters who had been demanding answers for years, felt deceived. There was open revolt online. There were calls for her impeachment. The political fallout was significant enough that the White House and the DOJ had to make adjustments to how they were handling the optics of the entire Epstein file release. But here is what made it worse. Bondi did not just mislead people about what the binders contained. She went further. She issued what effectively amounted to a legal memo, a formal position, stating that there was no client list, there was no evidence of blackmail, there was no one else worth investigating, and there were no further prosecutions possible. Nothing to see here. Those 4 words. That is essentially what the Attorney General of the United States told the American public about the most consequential sex trafficking case in a generation. Nothing to see here, and that claim has not held up. Not even close. Let's look at why that claim fell apart. If it were true that there was nobody else connected to Epstein worth investigating, nobody whose conduct rose to the level of criminal prosecution, then you would expect that conclusion to be reflected internationally. You would expect that other countries with their own law enforcement agencies, their own prosecutors, and their own legal systems would arrive at the same conclusion. That is not what happened. Other countries have already moved forward with investigations. Arrests have been made. Cases are being built. In the United Kingdom, legal pressure around figures connected to the Epstein network has continued to grow, including scrutiny of Prince Andrew, a figure whose connections to Epstein were documented in photographs, in testimony, and in civil litigation that resulted in a private settlement. Thus, these are not fringe conspiracy theories circulating online. These are active legal proceedings in foreign jurisdictions. And the contrast is almost impossible to explain away. The United Kingdom is investigating people connected to Epstein. Okay. The United States Attorney General, whose own government collected 3 million pages of evidence on Epstein and his network, is saying there is nobody left to investigate. That is a problem, a serious one. Now let's talk about the document at the center of the current congressional fight. This is not a rumor. This is not a leak. This is an official document, a de-investigation from 2015 that was supposed to be released as part of the veto-proof congressional mandate requiring Epstein-related files to be made public. The D-probe involves allegations of drug distribution, specifically club drugs and an alleged prostitution ring. According to reporting by Bloomberg, the investigation extended beyond Epstein himself to more than 10 other individuals. That matters enormously. Because if that investigation identified 10 or more people connected to Epstein's operation and they were never charged, the public has a legitimate right to know why. But when Congress and journalists looked at the released version of that document, they found pages and pages of heavy redactions. Not the targeted redactions that are legally permitted under the Epstein disclosure law, the kind that protect a victim's name or a confidential source. Blanket redactions, entire sections of a federal investigation into sex trafficking and drug distribution, blocked from public view. And Congress is asking one very simple question. Why? Epstein is dead. His organization has been dismantled. The investigation is years old. The law specifically says this kind of blanket redaction is not permitted. So why does this document still look like this? That question has not been answered. And the silence around it is becoming louder every day. Now we arrive at the most important figure in this story, who is not Pam Bondi, Todd Blanche. Blanche is the Deputy Attorney General. He is a former defense attorney who most famously represented Donald Trump in his New York criminal hush money trial. He is now the second highest ranking official at the Department of Justice, and he has become the face of the Epstein file rollout in a very specific way. When the pressure on Bondi became too intense, when the political fallout from Bindergate was damaging enough, Blanche stepped forward. He signed the letters to Congress during the piecemeal file releases. He did the press appearances on the Epstein rollout. He became the DOJ's public communicator on this issue while Bondi stepped back. Everyone noticed. Because this was not a routine policy matter where a deputy handling paperwork makes sense. This was the most politically sensitive file release in the modern history of the Justice Department. Sidelining the Attorney General was not subtle. And now lawmakers are raising a new question, not just about what the files contain, but about whether Blanche himself is managing a cover-up. That is the word being used, cover-up. And that word carries weight. Let's examine what Blanche has actually said. In a podcast interview, a setting that is notably more comfortable and less adversarial than a congressional hearing, Blanche made several statements about the Epstein investigation. He said he was not defending Epstein. He said the department is pursuing every perpetrator everywhere. He said the narrative that the DOJ is ignoring Epstein victims is false. On the surface, those statements sound reasonable. They sound like a responsible official defending his department's record. Welcome, Suni. But look closer. He is describing the criticism as a narrative. His word, narrative. The criticism is not coming from political opponents with an agenda. The criticism is coming from the victims, the women, and in some cases, girls who were trafficked through Epstein's network. Who gave depositions, who filed lawsuits, who spoke publicly about what was done to them, who asked for years why more people were not held accountable. You cannot describe their questions as a narrative. Their testimony is not a narrative. It is evidence. And when a senior DOJ official dismisses that evidence with a single word, narrative, that is not just a political problem. That is a moral failure. But here is where the story gets even more complicated. Blanche was asked directly, point blank, whether the department was confident that Epstein's death was a suicide. His answer was yes, completely confident, fine. That is the official position. The medical examiner ruled it suicide. There are people who accept that ruling. But then in the same interview, he was asked about the surveillance footage, specifically about a figure seen on video entering or approaching the area near Epstein's cell around 10:39 at night, the window in which Epstein's death occurred, orange notably being the color of inmate clothing in that facility. The question was simple. Do you know who that person was? Blanche's answer was, I don't think we know. And when pressed on whether that figure's presence falls within the window when Epstein could have died, Blanche confirmed that yes, it does fall within that window. Stop and absorb what just happened there. The Deputy Attorney General of the United States confirmed he does not know who was near Jeffrey Epstein's cell during the time Epstein died, and he is still confident it was suicide. Those two statements cannot both be true without explanation. Either the DOJ knows exactly what happened in that cell block that night, in which case they should be able to identify every person on that footage, or they don't. If they don't know who that figure was, then the basis for their confidence is incomplete. And incomplete confidence is not confidence. It is a position. There is another claim Blanche made that deserves direct scrutiny. He was asked about accountability for the prison guards on duty the night Epstein died. His answer was that the guards had been prosecuted and that there was a non-prosecution agreement, and that even if it wasn't the accountability people wanted, it was accountability. That answer is factually misleading. Here is what actually happened. The guards were indicted. That is true. But then, in an extraordinarily unusual move, the charges were dropped, not because new evidence emerged proving their innocence, not because a thorough review concluded they had done nothing wrong. The charges were simply dropped. Indicting someone and then dropping the charges is not accountability. It is the appearance of accountability without the substance. In fact, in some ways, it is worse than never charging them at all. Because dropping charges after an indictment can actually shield individuals from future prosecution in certain legal contexts. Blanche knows this. He is a former defense attorney. And yet he sat in that podcast interview and described dropping charges against the guards who were on duty when the most important federal witness in a generation died in their custody. As accountability, that answer was not an oversight. It was a choice. Now let's bring in the congressional dimension, because this is where the story is heading. Congress, and this is important, is controlled by Republicans. The House of Representatives, which is responsible for oversight of the executive branch, has a Republican majority. That means for a subpoena to be issued against a Trump administration official, at least some Republicans would have to support it. And that is exactly what has happened. The subpoena against Pam Bondi is bipartisan. Republican members of Congress alongside Democrats have decided that the DOJ's handling of the Epstein files does not meet the standards they established through law, that the redactions are not legally justified, that the meetings between congressional staff and Justice Department officials are not sufficient. They want sworn testimony. They have set a date, April 14th, for Bondi to appear under oath before Congress. This is not a cable news spectacle. This is a constitutionally mandated oversight process. And it carries real consequences. Congressman Robert Garcia made the stakes clear. The private meeting happening between lawmakers and Bondi and Blanche, the confidential meeting that was arranged to discuss the files and the redactions, is not a substitute for sworn testimony. It is not a negotiation. It is not a compromise. It is a preliminary conversation before the real accountability begins. Bondi will be under oath. And when you are under oath, you do not get to say narrative. Let's talk about what is actually at stake in that D document. The 2015 D probe is not just another government file. According to Bloomberg reporting, the investigation covered not only Epstein, but more than 10 individuals linked to his operation. It examined club drug distribution and an alleged prostitution ring. If that document contains the names of people who were identified as potential co-conspirators, and if those people were never charged, then the unredacted version of that document would effectively show who the government knew about and chose not to prosecute. That is explosive. Under normal circumstances, the DOJ has a legitimate argument for protecting the identities of individuals who were investigated but not charged. The legal theory is that people should not have their lives destroyed by investigations that did not result in prosecution. That is a reasonable position in ordinary cases. But Congress decided this is not an ordinary case. That is precisely why they passed a veto-proof law overriding the normal rules. They looked at the Epstein network, its scale, its duration, the number of victims, the political connections involved, the sweetheart deal Epstein himself received in Florida, and they said, the normal rules do not apply here. The public interest in transparency outweighs the normal protections. And the DOJ is effectively saying back to Congress, we disagree. That is a direct constitutional confrontation. And it is playing out right now. Here is the strongest argument in Blanche and Bondi's defense. It deserves to be presented fairly. Their argument is essentially this. The department released 3 million pages of Epstein-related documents. That is an enormous volume of material. It represents a genuine and unprecedented disclosure. The redactions that remain are legally justified under existing law, even if they are politically unpopular. And the question of whether to pursue additional prosecutions is a legal question, not a political one, that requires actual evidence meeting the threshold of a criminal case. That argument has some merit. 3 million pages is real. Many of those documents were genuinely new and contained information that investigative journalists, victims advocates, and the public had never seen before. And it is true that political pressure, however well-intentioned, is not the same as prosecutable evidence. But here is the problem with that defense, a serious one. The defense only works if you trust the judgment of the people making the decisions about what to release and what to redact. And the track record here does not support that trust. Bondi personally told the public there was a client list on her desk, and then there was no client list. She declared there was nothing else to investigate, and other countries immediately demonstrated that was not true. Blanche described dropped charges as accountability. He described victims' testimony as a narrative, and now a heavily redacted D document sits in front of Congress while the department insists the redactions are appropriate. You cannot spend months eroding public trust and then ask for that same public trust when it matters most. That is not a defense, that is a contradiction. A deep one. Let's pull back for a moment and look at the broader pattern. What we are seeing with the Epstein files is not simply a bureaucratic disagreement about redaction standards. It is something more fundamental. It is a story about power, about who gets protected when powerful people do terrible things, and about whether the institutions designed to deliver accountability are capable of doing so when the people involved are connected to the highest levels of government and finance. Epstein's network, by its nature, implicated people across the political spectrum. It crossed party lines. It crossed national borders. It crossed decades. That is why the instinct to bury this story is so strong and so bipartisan in its own way. Under the Obama administration, questions were raised. Under the Trump first term, questions were raised. Under Biden and Merrick Garland, a DOJ Inspector General report acknowledged problems with how the original Epstein death investigation was handled. And now, under the second Trump administration, with Bondi and Blanche at the helm, the same pattern continues. Every administration says, nothing to see here. Every administration insists the accountability has been done. And every time someone looks closely, really closely, they find something that does not add up. An orange-clothed figure on surveillance footage that nobody can identify. A D probe with more than 10 names that cannot be released. Prison guards who were indicted and then had their charges mysteriously dropped. A client list that was promised and never materialized. These are not conspiracy theories. These are documented facts. And the fact that they persist across multiple administrations, across multiple political parties, is the most important part of this story. because it suggests this is not about party affiliation. It is about something else, something deeper, something that powerful people across the political spectrum have a shared interest in keeping buried. What happens now? April 14th is the date that matters. When Pam Bondi sits before Congress under oath, she will face questions she has so far been able to avoid. The carefully managed podcast interviews and the private meetings and the piecemeal releases, none of that will be available to her in that room. Under oath, you answer the question that is asked, or you invoke your Fifth Amendment right not to answer, which carries its own political cost. She will be asked about the Binder incident. She will be asked about the D document. She will be asked about the redaction decisions. She will be asked about her early claims that there was nothing more to investigate. And Todd Blanche will be watching from the sidelines, knowing that the same scrutiny is building around him. The D document question will not go away. Congress made that clear. The bipartisan nature of the subpoena is significant. It means the pressure is not just coming from Democrats looking for a political fight. It is coming from members of Bondi's own party who believe the law is being broken. And beyond Capitol Hill, there are ongoing proceedings abroad. Cases being built in the United Kingdom and elsewhere. Those cases will produce evidence. That evidence may eventually reach back to people in the United States. The walls around this story are not getting thicker. They are getting thinner. There is one more thing worth saying before we close. The victims have been here the entire time. While politicians debated and officials gave press conferences and journalists counted redactions, the women who survived Jeffrey Epstein's network have been asking the same questions for years, decades in some cases. They are not a narrative. They are not a political football. They are human beings whose lives were altered by a criminal network that operated for years with the apparent knowledge and protection of powerful people, and who have been told repeatedly that the full truth would come out. It has not come out. And every time an official stands before a microphone and says everything is fine, they are saying it to those women too. That is not an abstraction. It is a real thing that happens to real people. And it is the most important reason why this story matters. Beyond the politics, beyond the legal arguments, beyond the constitutional confrontation between Congress and the Justice Department. The question of what Epstein's network actually was, who actually ran it, who actually protected it, and who actually knew, that question deserves a real answer. Not a binder, not a podcast, not a memo saying nothing to see here. A real answer. Moments like this rarely announce themselves as historic. They arrive quietly in redacted documents, in dropped charges, in confident answers given to questions that the evidence does not support. But sometimes, if you look closely enough, you can see the outline of something much larger than what is visible on the surface. Right now, Congress is doing what it was designed to do. It is saying you answer to us, and through us, you answer to the people. Whether that accountability will actually come in a courtroom, in a congressional chamber, or in the historical record remains to be seen. But the pressure is building, and the documents are talking. Even the ones they tried to keep quiet. Well,